What is the proper way to get the message across to the Indiana judicial system that something is wrong with the case against Richard Allen, the man accused of being the Delphi killer? Of course, a writ was submitted just the other week, came back from the attorney general saying, nope, you should have filed an appeal. And the attorneys turned back and said, no, a writ is the only remedy for this. An appeal is inadequate. What does that mean? Here to make all the sense in the world of it, Bob Motta, defense attorney, host of the podcast Defense Diaries. So we have a new chapter. We have a new response now from Richard Allen's attorneys to what we were talking about last week with the attorney general's response. Where does this take us now?
Hey, what's up, T? How you
Hey,
doing, man? Um, it's interesting. It's at this point finally because we had the response from the attorney general, we had the response from Judge Gull and her attorney, and then we had a response, a reply from Kara Weineke and Mark Lehman, who are the relator, Richard Allen's attorneys, and kind of after you read through it all. There's a couple things that are going to have to get addressed by the Supreme Court of Indiana, and first and foremost, they're going to have to decide whether or not Gull's argument that they didn't take that critical step, that being what they call an interlocutory appeal, they skipped that step and went right to the Supreme Court of Indiana. And of course, Gull's position is that because of that procedural hurdle that they did not clear in their estimation, that it shouldn't even get to the merits, that it should just be rejected based on that alone. Like they clearly think that that was the strongest argument because you can always tell in terms of when you're reading briefs or responses, typically the strongest argument is going to be the first argument that you read. And as they get weaker throughout the document, that's, your weakest will typically be your last or maybe your second to last, depending. I've seen some lawyers, stick their best or second best argument last, kind of leave the whoever's going to be ruling on it, whether it's the judge or the appellate court, or in this case, the Supreme Court, with a strong argument as opposed to a weak one. But uh, if they do find the Supreme Court of Indiana finds that the reply from Kara and the relator was uh, persuasive,
hmm
in the sense that essentially what you said, where they're arguing, look, that wasn't a remedy for us.
hmm
We couldn't do that. And the reason that we couldn't do it is because Richard Allen's attorneys had been removed from the case. And how can two attorneys that are no longer a party to the case file an interlocutory appeal, which is an excellent question.
hmm
Because that basically leaves a situation where Richard Allen then has to try to go to his subsequent counsel that has been appointed by Judge Gull, handpicked from her county, and ask them, hey, I'm sure you guys are great lawyers, but the bottom line is I want my old attorneys back. So I'm asking you guys to file an interlocutory appeal seeking to bring my old attorneys back, and knocking you guys out of the case. And just the concept of that is kind of hard to grapple with because I mean, we can't pretend that this type of case isn't a career maker. No matter how long you've been trying cases, you get a case like this that's this high profile, where you potentially have an actually innocent client in a case that's this high profile. It's a big case.
hmm
It's the kind of case that defense attorneys want to get, and they're not going to be, very excited or willing to knock themselves off the case, because ultimately, that conflict for those attorneys is real,
hmm
because they have to do what their client wants them to do.
Sure.
I mean, at the end of the day, I think that it would be a very It would be a big ask, but it would be something that they would have had to have done,
Hmm.
at least theoretically.
Yeah.
Whether or not they would have said, "Oh, well, we just don't have time to do it. We only have a couple days. There's no way we could get it done." And the other issue is, would Allen have been able to even get notice to his lawyers that he wanted that done? Would he know to ask them to get that done for him?
Sure.
Those are all things. So my hope is that it makes it to the merits. My hope is that the Supreme Court is going to rule on the merits and whether or not Judge Gull acted within her discretion to remove them. If her discretion and what she viewed as that gross negligence thing that she used,
Hmm.
if what she claims amounted to that, and if it did, in their estimation, does it outweigh Richard Allen's right to counsel, his Sixth Amendment right to choose his own counsel?
Hmm.
So those are the things that are ultimately going to get ruled on. But hopefully we get to it,
Yeah.
because ultimately what will happen is if they kick it back and say, well, you guys, you did skip that one, what they call condition precedent, by not by failing to file that interlocutory appeal, so we're not going to even get to the merits of the case, and they kick it back, then Richard Allen's stuck with his two attorneys.
Can they go
And
backwards? Can they go backwards and do the interlocutory appeal at this point, or because they skipped that step, is it like null and void? Can they make a corrective action here at this point?
well, I I had suggested to Kara, the attorney, because I've been trying to help them,
Hmm.
as a member of the defense bar, at least. And also, since I've been present in all the hearings, to try to supply them with information in terms of what have I observed and things of that nature at the hearings. And, we brought that up to her.
Hmm.
Do we think that it might be a good idea just in case? And we had given her, that concept of possibly doing that prior to Gull's response being filed, because we had kind of foreseen that that might be the argument that they would come with. And their feeling was that they felt pretty comfortable with their argument that that was not an available remedy to them, being the interlocutory appeal, for the reasons I basically just stated, and that their fear was that if they did go and file that, and it would have had to have been within 30 days of the final order, or once they get a certified copy of the order,
Hmm.
because they have to request that. And basically, Gull has to agree to it, meaning that Gull would have had to have agreed to an interlocutory appeal being filed. So, I mean, is it possible that she could have said, "Nah"? I think that she probably would have agreed to it, because that would have been a bad look for her,
Hmm.
had she declined to uh, basically push that thing through to the appellate court, because that's one of the necessary steps, is that the trial court judge
Hmm.
has to basically say, okay, I'm in agreement to it, or with it, and send it up. So, they think that had that been filed, the interlocutory appeal, while this was pending, that would have given Scoyne the ability to just say, oh, well, we're going to pull out of this thing now. We see that you filed the interlocutory
Hmm.
appeal, so we're done. You know what I mean?
Hmm.
So that was kind of their feeling on it. Now, if you're asking, like, moving forward, it then becomes a timing issue,
Yeah.
because they've got, like I said, 30 days to get, their notice of appeal on file, or get their appeal on file. And obviously from the 31st of October, or November 1st would technically have been the 30th day. They might have an issue with the timing of it at this point.
Hey, it's Tony Brueski. If you want more of our interview with our guests, be sure to check out our podcast, Hitting Killers with Tony Brueski. Just search that wherever you download podcasts and press subscribe. Also, you can check out our YouTube channel for the full video version of the interviews as well, under the same name, Hitting Killers with Tony Brueski. Check it out, subscribe, binge, and enjoy. Thanks for watching.